greatly, homie.
What it do, KTTeeV audience? Today we coming at you with the first episode of Raising the Bar.
Raise the bar.
Raise the Bar. My name is Kendrick Thomas, better known as KT, and I got my partner with me today.
My name is Sam Wesley. I'm an attorney in Houston, Texas.
Yes, and so today, can you talk to us a little bit about why we're here today, Mr. Wesley?
Well, I think we're here today because the last time you had me on the Daily K podcast, I think a real connection was made.
Yes.
We saw some synergies where we could definitely get information out to the people to help the community, and so that's just kind of where this started. Today, what we wanted to talk about, what we initially said was, to just talk about child support, talk about things that, typically people deal with in family courts, right? Yes. So, child support, custody, divorce, those are the things that you typically see, and those are the things that I also have experience with. But also what we wanted to talk about today was like, how do you get through all of the feelings that go along with family court? It's inherently just overrun, I guess you can kind of say in some ways, with feelings before the facts.
Okay. And
when you have that kind of situation, it definitely has the ability to cloud the issues for the judge, for the court, even for the attorneys. And so today we want to talk about some strategies to be able to keep the truth in front.
Yes.
That way you can have a more successful outcome when you're actually in court.
Yes.
Yeah.
And like you said something earlier that was really important as far as about the emotions.
Yeah.
And like you said, that's kind of where we play it out, but through litigation.
Yeah.
And so the question would be, do people drop the suits? Like, let's say we make up, or is it
Yes. I've had a few cases where people have actually paid me the retainer.
Okay.
And I filed paperwork. We would have hearings set, discovery would have been sent out, and then they would tell me that they're going to reconcile.
Okay.
Actually, I've had a few instances of it, yeah.
Yes. All right, man, kind of talk to us a little bit about what brought you with this topic.
Just because you see a lot of pleadings. So a few things, right?
Yeah.
So you take on inherently, I think, maybe like the personality of your client in some ways. Like, they come to you with, and people come to folks with their worst problems. I've heard some terrible things that people are actually going through, and it's very sad. So, your heart kind of goes out to the people that are reaching out to you for help. And so there have been instances where I've been in court and or I've forwarded the petitions or motions that people are sending or filing in court, and the clients would be shook. And you could tell when it's beyond the shook in regards to anger. It's more so they're upset because somebody would really put something so false into emotion. And I made the mistake of trying to, chase down a lie and prove it to be, untrue, which is a waste of time. And so what I've started to do now, what I found is really helpful, is there are procedural vehicles that will help you eliminate all the issues that are not relevant to your case. That way you don't waste your time and money, and energy. It helps them to wind down too, so they can more effectively help you assist them.
Yes.
So that's kind of how this has gotten started. Is I've seen, for example, adultery has been alleged in several of my petitions. And so adultery by the Texas Family Code is actual sexual intercourse with someone else. It's not a text message conversation. It's not carrying on an emotional relationship with someone else. It's actual sexual intercourse between somebody that's not your spouse and you. And so because of that, someone can say they're either, one, it never happened, or two, it's just something that person can actually prove.
Yes.
And if it's not something that they can prove, there are ways to get that eliminated from the pleading, from the bat, and that's called a motion for summary judgment.
Okay.
Yeah.
Okay. And so, what do you think is the driving force of the line? I mean,
Emotions.
We gonna dig.
Emotions. You can tell the difference in your clients or parties.
Yes.
All right, when one party is actually done emotionally with another party, right? The presence about that person is just different. Even if someone, my very first case, the husband in that case initiated the divorce.
Okay.
and we had to file what's called counter petitions, etc. And we can never get the husband who actually initiated or started the divorce proceedings to participate in the divorce proceedings, down to the fact that he wouldn't even sign the divorce decree. So, people just, they can use the legal proceedings as a form of control. They can use the legal proceedings as a form of harassment. They can use the legal proceedings as a way to keep their attachment to that person in some form or fashion, just because they don't want it to end. So they'll drag it out as long as they want to. So, or they want to use it to hurt somebody. And I've seen that too. People will do it just to hurt somebody. Or, for example, if you are alleging adultery or some type of anything to where a marriage is dissolving, that will also allow you to get a more of the community estate. A judge will look at relevant factors, and that will be a factor in what a court will decide whether or not community property should be split evenly, or if one party should get more because it is the fault of the other party that the marriage has dissolved and is no longer supportable. So, I mean, people will lie for any number of reasons, and I don't want to say that an attorney does it, because I feel like all of us should be striving towards ethically, and we're bound by ethics to not put anything that we know to be untrue into a pleading that can actually cause sanctions. But you have some who might not know the facts of their case. You have some that attorneys can't be unscrupulous. That's and they will use it as a strategy to get what they want. It's incumbent upon the other attorney, especially when you know that something is patently false or cannot be proven, for them to arrest that before it gets in front of a judge. Because once it gets in front of a judge, it gets in front of a somebody that's going to determine based on the facts. If you have a lie clouding up the proceedings, clouding up the issues, it hurts your case.
Yes, very much so. Yeah. Very much so. Credibility is everything.
I mean, not even just the credibility, it's the fact that the judge will basically get tired of y'all arguing in court. Okay, family lawyers and the family courts are a vehicle by which people will, just have a legal way of arguing in court. They're just carrying out whatever argument they have personally into a legal arena, and then attorneys can also take on that personality as well.
Wow. So how let's say I'm to that point, how does that process go? Like, when you get a client and they want to go through the process, what does it look like at y'all?
Which process? So, I mean, it could be a number of different processes. So for a divorce, all right, so with a divorce, of course, you start with, and I'm going to take you from the very beginning just so I can give a complete picture. So you find an attorney, you have a consultation, you explain the facts of your case to that attorney. They will tell you, based off of the facts that you told them, how things can work in your favor or not work in your favor. The attorney will ultimately decide whether or not they will take on your case. Once they do, you file a petition. Or if there's already a petition filed for divorce, you file a counter petition. And in that, petition or counter petition, whatever that pleading is, you say what you want from the court. All right. In addition to that, if somebody has, so let me not move on from that. So when you're asking for stuff that you want from the court in a divorce, it could be you want to be the person that determines, has the exclusive right to determine primary residence of the children, right? You want to determine whether or not you have a geographic restriction for the kids, child support, spousal maintenance if you qualify for it, who keeps the house, what's going to happen with the sale of the house if that's ordered, if there are a number of debts. Like, all of that stuff has to go into your pleading, because if you don't ask a court for it, they're not going to give it to you. All right. You can always amend, but if you get into court and you try to bring up issues, a sharp attorney will say, Your Honor, that wasn't pled for. And so the court will actually keep that from being something that you can ask for because you didn't plead it. Okay. If you are ever served with divorce papers, you need to get an attorney or immediately, consult counsel or file an answer, because if you don't file an answer within a certain period of time, and it's a very obscure way of saying the rule, but you have between like 21, 25-ish days, okay? You could be, somebody can get a default judgment against you because you haven't answered the lawsuit, which means that anything that they've asked for, they're gonna get it. Because you haven't answered. The court has said that you deny what the allegations are, etc. So, so that's the first step. Then if you have children involved, or if there's significant assets involved, you might want to have what's called temporary orders. And you also ask the court for a temporary restraining order. And the restraining order is in place actually to protect both parties. More counties, some counties will let you just get a restraining order against one party, but most counties, like Harris County, will say both parties are going to be jointly and mutually restrained, which means that neither one can do any of the things that you put into the restraining order. So when it comes to property, that could be stuff like, not cutting off the lights, not changing the yard man, not moving furniture out of the house, not trying to move the house out of one person's name. It could be also keeping all your money in the bank account, not changing the beneficiaries on your life insurance policy. So I mean, they can, yes, okay, yeah, especially when you're talking about substantial assets. Then also, when it comes to children, you want to put in place temporary orders to determine, like, while the proceeding is going on or while the divorce is being litigated, who's going to be the one that primarily keeps the kids? What's going to be the child support? Who's going to determine where they go to school? And then there also be things like you can't hide the kids because people use kids as pawns. You can't hide the kids from the other party. You can't withdraw them from school. You can't speak negatively about the other party. You have to allow for forms of communication, like all those different things. So that's a part of it. Then you have the hearing, you have the outcome, and then in between all that, you have mediation. Yeah. Somebody might you might need to have a parenting class. There are a lot of steps that kind of go into it. What I'm finding is, and I haven't used this tool as much as I should, but I'm starting to use it now because I'm starting to see so many things that are untrue show up in pleadings. Discovery. Like, that's a big part, but it's also a very expensive part of family law because, again, it's overrun with emotion. So if I file discovery, I'm expecting discovery to be filed in response to what I'm doing. So now what that means is all the things that I'm asking or trying to assert is, or try to understand what somebody else's arguments are, or what theories they're going to put forth, or what witnesses. That's all of what discovery is. It's basically saying what the other party is going to bring forth in court. All right. You want to see what evidence or what truth they're trying to prove as much as you can, and vice versa. But that runs up the score. You're getting paid by the hour, so now you have to, get the discovery, explain what it is to your client, make sure that they're completing discovery as they should, and then you also have to sift through those responses, edit them, correct them, and then you also have to do the same for the other party. Not do all the correcting, but you have to get that information back and then read it. It's very expensive. But that gets you the result that you want because the truth is going to come out in that documentation.
That's really all it's about. Gotta get that truth out.
I mean, that's the thing that keeps you from wasting a lot of time, even for your attorney. I mean, as much as you can prove true or not true, it just helps you to be able to make your arguments much more clear, your issues much more clearer in court. So I'm what is this? This is December. Yeah. So I'm 7 months in, something like that. So I'm glad that I've kind of learned this lesson now, because when you get a situation where one person cannot prove what it is that they're alleging, you can file for a summary judgment. And that means that any of those issues that are not true and there's no evidence to prove them to be true, the court will eliminate those if you file that procedural vehicle in time before a hearing. Okay. And it's extremely helpful. Yes. Extremely helpful.
So would you... I've seen people who say, well, I'm just going to do the divorce myself. Would you recommend that?
It depends.
Okay.
If both parties are really done with each other, yes. I mean, you definitely could do it yourself. It makes more sense to do it yourself because if y'all could come to an agreement as far as like how you're going to split assets, or if everybody just takes whatever is their own, it's easy. I mean, it's $300 with the court. If you're indigent, which means that you make, below a certain amount of money, the court will waive all of the costs. It's not until parties kind of renege on their agreements, which happens often, that pro se does it, and it's called pro se when you represent yourself. That pro se isn't something that a party should choose. If you have substantial assets and there's not an agreement, you should never be pro se. Because even if you have really good facts, if you don't know the law or more specifically the rules of evidence in court, you'll never be able to get your case out against not even a good attorney. It could just be any attorney is going to know that they can object or they can say things in court or admit evidence in court that you're just not legally trained to know what's admissible and what's not, what statements can be said and what can't be, etc. So if the other party has an attorney, never represent yourself ever. I would never recommend it.
And you'll know as soon as you get that service.
Yeah, I mean, I've seen folks in court be pro se, and it's not pretty. Not pretty. Yeah, and also it irritates the judges. I mean, and it shouldn't, because it's your right. It's your right to be pro se, right? But it absolutely irritates the judges. The judges don't like it. Yeah, because
you have that fumbling on the play.
Yeah, and then if you have another attorney in there, I mean, I'm telling you, it's just a slaughter. I've never been in a situation where, well, just one situation, and the judge was actually pretty kind in that case, but where I did have one party. I've had a few cases like that, but only one in a hearing. And she didn't have an attorney, and the judge, even before I even had to raise any of my issues or arguments, told her that she didn't prove her case, so she just stopped it, right? So, which was good because, I didn't want to, I was going to do my job, but I didn't want to have to do my job because it wouldn't have felt right just beating up on her like that on the stand. But so courts typically just don't want to see it. Yeah, and other thing is when you're pro se, you don't know the subtle cues that the judge will give you to let you know to wrap it up, or you basically lost your case or they made their mind up already, or you don't know when they're getting irritated. You can't pick up on that without having that experience in the courtroom or with that particular jurors.
Yeah, them judges can be pretty.
They can be, but they can also be very fair. The thing is if you know the law, you know the law. And so the more that you know the law, the judges do respect that. I think there's just a certain way that you stand in court. A certain way that you speak in court when you're very confident about what the law says, about what you're saying. I think the judges also just kind of feed off of your confidence. But if they have a disagreement, you need to be prepared to prove your argument to the judge in a way that it makes sense. And you have to know the law to do that. But for the most part, I've seen judges be fair. I can't say that I've had an unfair. I've had some crazy experiences in court, but I can't say, for the most part that all judges are unfair.
Okay.
And I think any attorney would say that.
Yeah, especially when you gotta just keep it cautious.
Yeah.
You'll be back again.
Yeah, I'm gonna be back in front of the judge. I'm gonna be right back in front of the judge.
Okay, so then when it comes down to the, I guess the rulings. So what I'm seeing, you seeing like some of the factors that say, okay, this is how much you gotta pay.
So child support. So child support primarily is determined by your first, and I hope I'm right and I say this because I know that the law changed with the last congressional session, but when I was in school, which was not too long ago, it was the first 8550 of what's called your net resources. All right, so and your net resources are your gross pay minus a few deductions that the court allows statutorily to be included, like union dues, which you might pay for insurance, and if you already have any other dependents, and then like what your exceptions are, but there's a cap on that as far as what will go into the calculation. But all of that's written into the family code. And so how child support works is, and there's a scale, there's a table to try to take the guesswork out. So your first kid is going to be 20% of your net resources. If you have kids by the same parent, same mother or father, or as long as it's the same parents, okay, it's going to go up incrementally by 5% each time. So 2 kids is 25, 3 kids is going to be 30, all right? It gets tougher when you have an existing support order and then somebody's asked to pay child support again for another child. So it's not going to be on the same scale. Okay, so let's just say that you have 2 kids with 1 parent, right? So that's going to be 25%. That other kid with the other parent is going to be, I think it starts at like 16%. So already off the bat, you're coming out for 41% of what your net resources are. That's independent of taxes. That's independent of anything else. And so that can possibly put somebody living less than 50% of what their check is, right? So that's what goes into the calculation. So it's all statutory. But now once you get over the 8550, the court will look at some other factors, right? So if you have enough resources for it to be 8550, that party's making pretty good money, right? And so they're going to be looking at the lifestyle that the child is accustomed to. And that could be, and I'm going to refer back to like some cases that I've read in school, like stuff like horseback riding. In one case, a kid often went to birthday parties. One kid was in private school. It's private school tuition. All of those things will go into the calculation. And sometimes, even if you are still within the standard guidelines, in some circumstances, the court will still look at those things and see what is most appropriate and what's in the best interest of the child. And if the child or if the parent should have to include that into the support order. So that's how child support is calculated. It starts out of a table in the family code. It's statutory.
Okay.
Yeah.
Okay, but everything black and white though.
For the most part, it is. For the most part, it is. Yeah. Then that's what And then what goes into that. So if you have somebody that just has a straight up salary, that's easy. Self-employed is going to be a little bit more challenging, right?
I know a few barbers. You know.
Yeah, man,
and
because
stuff
you
like
know, and they're gonna be doing it off of tax returns, and then you know that could be a challenge because barbers deal mostly in cash.
Yes.
So that will, you know, depending on who the attorneys are and how much money they want to spend, like you can trace down how much money they're making, but is it really gonna be worth it?
Okay.
You know, that's what you have to look at. But so the courts will look at that. Courts will also look at if somebody is intentionally underemploying themselves.
Okay.
So that means, like for example, and these are all cases that I remember from school. In one instance, this gentleman was a doctor, and him and his ex-wife separated. He went through a severe depression, and then he just wasn't working, and he took a job at, I don't know, like a convenience store or something like that. When it was established that part of the reason why he was taking the job at the convenience store was to avoid paying so much in child support, the court ordered him to pay at least what he was capable of earning because he was making a choice to underemploy himself. The difference in that case, though, is because child support is not, it should not be a tool of oppression, even though it feels that way for the person that has to pay it, right? But, so for example, if a party wants to go to school to better themselves, and they may have a job that pays them $100,000, but when they get out of school, whatever job that they pursue to ultimately use whatever degree that they sought, of course, not going to make them still pay $100,000 if that person is honestly trying to find employment that makes them happy and fulfills them. Okay, so in that case, it's not intentional underemployment. It's this person choosing to do something that makes them happy and also in the pursuit of the education that they just chose. So, but it you know, it all depends on what the facts are of the case. Yeah.
Yeah, I'm just trying to see if we got this live going. I'm seeing everybody.
Is it working?
Yeah.
Okay.
Everybody saying anything, any questions out there? Everybody chimed in. Cause it's some good topics, man. And so then when we're thinking about the support order, is that already inside of, like we come to the table and you file everything at one time, or?
Yes. So if it's a divorce, you are, right?
Okay.
If it's a divorce, you are, or if it's just dealing with kids and the parties were not married, it's called a suit affecting the parent-child relationship. And so the very first thing that you'll file if there's no court order in place is an original suit, right? An original SAPSR suit is what, you know, legal professionals call it. And you always include child support and what's called conservatorship in there. Conservatorship is just another word for saying custody. And then you also talk about possession and access, which is visitation. Yeah.
Yeah, see, that's the next thing I wanted to ask about. So how do you, like, how does that play out in the court? Because I know you just explained about the money part, but like visitation, because I've seen where they ask the kids, you know, in some cases if they're old enough, but then on the other side of it, how do they do it for the little kids?
Okay, so since you said the kids that can kind of speak for themselves first is where we'll start. But in the family code, it says that any child 12 or over can confer in chambers with a judge who has, you know, jurisdiction, and the judge can weigh what that child says in addition to what's in the best interest of the child. Okay, so it can't just be that the child wants to go live with one parent versus the other. The first prong of what that, you know, actual regulation or statute says is it has to be in the best interest of the child, and if the child is over 12, you know, that will be given consideration. And I know I was just in Ector County, and there is only one family law court in Ector County, and that judge hears 100% of the cases, whether they're 12 or not, if they want to confer in chambers. And so some judges really do take that very seriously, just so they can at least sift through whatever the facts are that the parties are litigating in front of them. So the other thing is now, if the parties are not 12, if the child is not 12 or older, there are a few things that kind of go into that. You know, historically, you just see more moms with the kids and then dads not have the kids. I think as society becomes more progressive, you see that less and less, especially, you know, folks are still getting used to a lot of the new jurists that we have in Harris County, but especially, you know, the ones that were, you know, recently voted out, you didn't see a lot of dads getting custody in those situations. But the things that the court will look at are, like, what are the kids used to? That's the first thing, right? So, again, it's always going to be what's in the best interest of the child. And so they're going to look at, you know, the emotional safety and, you know, emotional, physical, mental welfare of the child, who's going to be the most stable parent, who has good plans for the child. Are there any issues or allegations of family violence, child abuse, neglect, abandonment, you know, a whole host of things. Are there mental issues involved? Is there, you know, addiction involved, et cetera? All of those things go into ultimately how a court is going to determine who is the custodial parent. Okay, excuse me. And then the other parent will be the non-custodial parent, and everybody has certain rights and duties that are equal. It's just that the custodial parent in a lot of cases will be able to determine where the child lives, what school the child goes to. If the parties live in the same county, typically you will see where the judge will put what's called a geographic restriction, where you have to stay in that actual county or surrounding counties that actually border that county, and that's so the child and the parent's relationship will not deteriorate from the distance.
And is that something that you asked for, or like the judge kind of put that
So you'll see people ask for there to be no geographic restriction, but if any parent really wants that to be in there and they live in the same county, they have to really prove, the party that wants to not have the geographic restriction has to show to where it will not impact the parent-child relationship in a negative way. Especially if there's an order already in place. Like if one parent just ups and moves to another state or outside of a county where now they're 100 miles or more, you've effectively changed the visitation schedule for the other parent, and by doing that, you impair the parent-child relationship, and so the other parent can enforce, the geographic restriction because now it's placing a burden on their relationship. So, you have a ton of legal vehicles to deal with that, but ultimately, the court's going to look at what's the situation as it is at the moment the suit is filed.
Yeah.
All right. And then when it comes to visitation, most folks have what's called a standard possession order. Standard possession order is the first, third, and fifth weekend, and the weekend actually is it's the first Friday of the month, right? So that will be considered the first weekend. So the first Friday is the first weekend, third Friday is the third weekend, etc. Most folks can get their children on Thursdays from 6 to 8. They have to take the child back. The alternate holidays, you get a couple hours on birthdays. And then, Mother's Day and Father's Day are always exclusively to whoever the parent is. And then summers can be broken up in a few different ways. Summers can be, you can have the entire month of July, which is 31 days, or you can break it up into basically 2.5 week periods over the course of the summer. But you still keep your weekends, first, third, and fifth weekends throughout that time. That's if the parents live 100 miles or less. When they live 100 miles or more, if one parent can consistently keep the normal visitation schedule, that's their right. They can elect to do that. If not, you typically default to once a month, and then you get spring break every year, and then you get, I think, 6 weeks.
And all this is kind of in the code.
This is all standard stuff that's already in there, and but you can always alter that. So, especially now, you see more orders that will say, basically, the parties can agree to whatever they want to. Right, but if there's no mutual agreement between the parties, then they have to follow the paper, right? And if you don't have a good relationship with the other party, the paper is the best thing that you have, right? And then, it protects your rights, right? It protects the rights of the child. It protects your relationship. So, I always encourage folks that don't have a court order, and most of the time you see that because folks don't want to pay child support. I always say go get on the paper because that's how you get access to your child. It's court ordered at this point. Right now, if there's no court order, there's nothing in the law that says one parent has to let the other see because there's nothing to govern their relationship right now, at the present time.
And do you deal with like the prenups, the prenuptial agreements? Is sometimes
I have not done any of those yet. I think they are actually a very good tool to have, even if you don't have substantial assets at the moment, right? But at least if you have the potential, right, to have substantial assets, or as a couple you guys have potential to have substantial assets, it's not a bad tool to have. If people look at it in terms of they're thinking that their marriage isn't going to work. I look at it like it's insurance policy. That's exactly what it is. And they're not terribly expensive to do, especially if you don't have a lot of assets that need to be included into the prenup. You just need to make sure that it covers what will be your separate property. It determines like how you guys will deal with community property upon dissolution of the marriage, etc. And that will govern as long as the other party is not coerced, as long as it's voluntarily agreed into. One person cannot actively conceal how much wealth they really have, and then still expect that to be considered to be valid, right?
Yeah, that's what I was going to say.
Yeah.
How do you, like, does adultery make the prenup agreement invalid?
Depends on what you put into the
What
prenup.
you put in it. Okay.
The thing of a prenup is a contract, right? And so you have to honor the contract, and the only way to break that contract is to show that it should be void at the moment that it was signed.
Okay.
Yeah. Yeah.
Man, okay, man, it's deep today, man.
I mean, we talk about some stuff that you know, I haven't had to deal with in a while, but I mean, but I think that prenups are, I haven't thought about actually offer the service, but I just don't advertise the service, right? But I mean, they're great tools to have. I would advise anybody to get one, and it has nothing to do with whether or not they think their marriage is going to work. It protects them in the long run. Divorce is a traumatic experience, right? So you're effectively starting over. And starting over from scratch is harder than starting over with at least some semblance of what you had while you were there. It just makes the transition easier. So I definitely recommend.
Okay. Yeah, there we go. We back.
That's right.
So, all right, y'all. We did part one where we kind of talked about divorce. We talked about court orders. Sam gave us a lot of terminology, I would say, tips to help us out. And so I guess as we come back for part two, basically we talking about what happens when everything is not working the way it should.
Okay.
Yeah, and so I guess we can start with let's start with the parental rights. So what happens now? If I'm given a court order of my visitation and I'm not following that, then what happens? How does that work?
The party that is having their rights impaired should file what's called a motion to enforce.
Okay.
A few different things you can do. First, you can start with a motion to enforce, and typically you see that when it's visitation. One parent is denying one party access to their child. After you have 3 times of that happening, you can file a motion to enforce. In order to get 3 good times, what you have to do is you have to let the party know that you plan on enforcing it. Even if it's written in a court order, you need to make sure that they have notice, actual notice. And then, so that's sending them a text message, email. Better to do it some type of written documentation. Even better if you have a co-parenting app that you guys can use that is court ordered to where you have to communicate about certain things. That way it becomes a record for the court.
Okay. So like when you bring in your text,
yeah, I mean that way you don't have to do a bunch of screenshots. You can just print it out. So you do that. You have to make the attempt, okay. And if the party does not still allow access while you're making the attempt, you have to make it very plain that you don't agree. And even though that's not written into all court orders, because you can make a mutual agreement, I've heard some judges say, well, you imply consent while because you agree to the deviation of whatever the court order said. You need to make it very plain that you don't agree. That way the party knows that, you're not consenting to what they're trying to, change or allow happen. And then you file your motion. In addition to that, depending on what the circumstances are, you might also want to consider filing a modification of the parent-child relationship, because, once a party starts denying access to a child, you have a material and substantial change in the circumstances of the parties. And so you can file a modification and, modify the relationship, as you see that you feel like it needs to be. Typically, when you file a motion to enforce, though, you have, you can get makeup time. That's actually can be it's a quasi-criminal proceeding when you bring somebody in court for contempt. And so that means that if a person doesn't have an attorney, they can actually get one appointed to them, because if the judge finds them in contempt, they can go to jail.
Yes, that was the next thing. So, like you say, you're not following. So then after a while, it's contempt.
Yeah, after 3 times, it's contempt to the court order. And I mean, after the first time it is, but you don't really come to court unless it's, 3 times. And then, it could be a $500 fine for each time that it happens. In addition to, you have a person's license suspended. In addition to, you can have a bond placed with the court to where if they violate the order again, that you forfeit that money over to the other party. You have to leave a deposit with the court. I mean, it's a number of different remedies that you have that can be, definitely punitive, for the offending party to prevent it from happening again.
Yeah, but that's deep, though. I mean, because like I said, you got a court order, you're hindering the relationship. I mean, there's a lot of things not happening. And so have you had to deal with that so far?
Yes.
Wow.
Yeah, I mean, you see that a lot where one parent denies the other parent access to the child.
Even with the court order.
Yeah, I mean, typically the parents that are in violation of the court order just completely disregard it. Some will say that they're ignorant of it. But it could be again, family courts are where people go to litigate their hurt feelings.
Yeah.
So, and so that's just kind of what you'll have to deal with. And so hopefully it doesn't come to where you actually have to have a proceeding, because if the facts are clear, I mean, what can you do?
Yeah.
You know, the facts are the facts. And so, in most cases, you try to reach an agreement to where you don't have to go to court, and it will be in the best interest of the offending party, if the facts are true, that they shouldn't want to go to court either to, you know, suffer through possible jail time and fines and attorney's fees.
Yeah, going
Yeah.
back to the truth though.
Mhm.
Man, dude, it's deep, man. And so, how long can you stay in litigation? How long have you seen like people staying in litigation do this in the 7 months you've been working?
And cases can go on for, you know, 6 months, easy. And then the thing is it really depends on the parties. So I have a divorce, or a client that I help with a divorce, and now I'm helping her, and she's recently divorced. And now I'm helping her just to even enforce the divorce decree that was signed just a few months ago. You know, it can be ongoing. It really does depend on the parties. I don't mind going to court, right? Like I like going to court, but I do try to resolve things outside of court. It's just better for the client. And preparing for a hearing takes a lot of time. So if you can reach an agreement that makes sense for both parties, it's definitely in the interest of the parties to do so.
An agreement here and what?
Yeah.
Like you say, people don't want to do it.
That's the other part is you can have some folks that have great deals in place, things that are just like extremely beneficial to them, and they'll walk away from the table for reasons that just baffle me. Yeah, of course. But it's still baffling, especially for me, a very hyper-logical, very, very logical person.
Yeah.
I don't see how you can walk away from something that's, you know, so stacked in your favor, but I've seen it happen a lot of times.
Man, that's a lot, man. I don't know. Like I said, I never been through. Of course, I never been married, so I can't go through it. But you know, I don't even know someone who's going through a knockdown, drag out like that, so to even empathize or understand. But
More people might be going through it than what you know.
Oh, yeah.
You just don't see them talk about it, you know, a lot. But I mean, it's not uncommon. A lot of the times in the issues with family courts, when there's a denial, especially with just a denial of access to the kids, there are a lot of unresolved issues between the parents that just keep manifesting in some kind of way.
Yeah. All right, man. I don't know where we need to go, man.
So the other one I think we want to talk about was like, you know, one thing that I get asked a lot is about child support.
Yeah.
And so first thing is child support. If a party is not paying child support, it doesn't allow them the ability to keep the children from them, because it's all court order, right? So I mean, the thing to do is to go to court and enforce, you know, what your child support order is. And then also, like, I mean, sometimes parents just fall on hard times. Sometimes, you know, circumstances change. They still might be trying to pay the order as it is. Their income can't support it anymore. The best thing to do for those parties is to talk it out. A lot of litigation can be avoided if the two parties just try to talk to each other. I mean, because ultimately it should be about, you know, the kids. And so I've seen that work, and I'm happy when I see that, you know, to work. And it's actually what I advise most of my clients to do first if they have that type of relationship, you know, with the other parent, is just try to talk through it first before we have to start filing paperwork. But if not, I mean, the thing to do is go to court. And but even still during that time, like the lack of payment of child support doesn't allow for one party to keep, you know, the other parent away from their children. And then if you feel like there needs to be a change in child support, I mean, this is either the party that's paying or the party that is receiving child support. If there is, so child support can be modified a few different ways. Within a year, if there's a material and substantial change to, you know, either one of the parties, that could be the child, right, or that could be the person paying it. If they're, so for example, if they lost their job, right, they can go back and request, you know, modification. It can also be requested, and it's typically standard. You'll see, or you get a notification every 3 years for your child support to be under review.
Every 3 years.
Every 3 years.
Okay.
And so every 3 years, and the Attorney General initiates this process, actually. So both parties will get something in the mail saying a review is warranted for your case. Do you want to do it? and it's still ultimately up to, you know, the parties to decide whether or not they want a review on the child support.
Okay, so it's not automatic.
It's not automatic, no.
Okay.
And then even still, like, the parties can still agree. They can still make an agreement to leave it as it is, or come up with a different amount that they think is reasonable and fair. You know, it's going to be profit for the child, but it doesn't have to end up in court. Like, court should be a last option, and the reason in family court where I think it's, you know, sometimes the first option is because the parties can't communicate. Yeah, it is key. It is key. I guess some other topics just dealing with visitation, like you'll see where, so supervised visitation is something that I see a lot of in modification documents, or just any type of conservatorship documents. Some people come out of the gate with what's called sole managing conservatorship. What that means is one parent has, there's no joint custody. Okay. Texas actually codes into the statute that it's in the best interest of the child for the parents to have joint custody. Okay. That is a presumption that has to be rebutted through your legal arguments, right? So if one parent is saying that it's not in the best interest, they have to prove to the court why. Typically, in proving that, what you have to show is some type of family violence, which means that, you know, there's some type of abuse between the parties, or families of the parties, or the actual children involved in the situation. Child abuse, you know, can run a whole host of things. Those things will, you know, allow a party to have, you know, sole managed conservatorship and visits be supervised, but you have to prove that out.
Yeah, that's what I was going to say, and that's going back to the facts part. So people making up stories though.
Yes. Yeah.
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 But the discovery bring all that out.
It should.
Okay.
Yeah, it absolutely should.
Okay. Well, yeah. Sorry to cut you out.
No, I mean, like it's up to the attorney. It's incumbent upon the attorney to like try to filter through all of this stuff, because you don't want those issues to get in front of a judge where you don't have anything to challenge their validity. Like the courtroom is not the place to challenge the validity of that evidence when you have a window to where you could already start attacking or preparing for it, et cetera. So, you know, when you get in court, I mean, of course you're gonna make your argument, but you really don't want court to be the first time you hear something, especially when it's dealing with allegations of abuse or family violence or neglect or anything like that, because you don't have a way to prepare for it.
Yeah. I mean, just thinking about that, I got a friend of mine back home in Shreveport. Man, he's going through that, you know, good dude, man, but that emotion, and so then she started just making all kind of allegations against him, man.
Parties do it all the time. Yeah. I mean, it's not one sex over the other, man. Yeah. Like I had a guy deny his kids mediation. It messed the mother up, because that was the first time either one of us had heard it, but he made paternity of the children an issue. And I mean, so like, people just don't fight fair all the time. And so you have to keep your client calm, because typically the human response is to, you know, throw a stone right back. But that doesn't help your case, right? It just clouds the issues or creates more issues. Now you got to try to litigate. You know, easiest way to make your litigation, in my opinion, efficient is you only chase the truth. You only try to prove out the truth. You don't chase a bunch of lies, because you're going to be wasting your time and energy when you try to do that.
Okay. Yeah. Man, I think. Man, I don't even know. I think that
is that it for today?
I think so, man. You know,
Okay.
I think for the first one, there was a lot of good information.
Okay.
Man. You know, I can't wait, man. I can't wait to come back for the next topic, man. I think we can kind of get this going to make sure that we're getting it out to the people, because
I'm done with that.
Like I said, people need information.
And you know, and especially with family court, any type of court, like me, but our people, I think we see more of the family courts in the criminal courts, and so the more exposure you are to how it should be or what you should be looking for in your own representation as counsel, I just think it helps you to have a more favorable experience when you have to go into court. Court is nerve-wracking enough as it is, but being unprepared in court is a completely different experience. Like nobody should, especially a client, should not know what that feels like. Yeah.
Man, see, now that's bringing more questions, man. We said being prepared. So, like, thinking about that, like, what is your prep time? Like, how does it? Woo? Or is it dependent?
Now it's starting to depend, but when I first started, I would do something on it, especially if I had a hearing, I work on that hearing, probably I start 2 weeks out. But the weekend before hearing, I probably spend a majority of the weekend on the hearing. Now what I do is I don't start moving towards preparation for my hearing until I have a very clear way of how I know I'm going to prove my case.
Yes.
And then that way I don't waste any time or, money for my client. And so sometimes I can reasonably put together, good arguments within a couple of days, but it's not for lack of understanding or preparations. I know my facts very well. It's sometimes you just have to take a mountain of evidence, but you can't take it to court because it's going to confuse the judge. So you need to take the best evidence you can to prove whatever it is. So, you should at least 48 hours. You should be definitely putting into at least. But sometimes it could be more than that. I mean, spend 2 days. But I mean.
And are you practicing outside of the city, like the state of Texas, period?
Just in Texas. I'm under license in Texas, but I've worked in Brazoria County, Montgomery County. I have a case in Jefferson County, one in Fort Bend right now. I have one in Ector County, which is in Odessa, Texas, which I drove to Odessa, Texas. It was a lot of driving. It was a bad drive only because I was extremely tired. But in preparation for the case too, right? So I mean, that on top of the driving, but it gave me a chance to like practice my arguments on the way up there. So
yeah, there you go, rehearsal.
Yeah, exactly. So you can make the best out of it.
Okay, man. Well, I think I think that'll do it for, like I say, for episode 1.
Okay.
Raise the bar. Man, how do they get in contact with you after this?
So I am on Facebook. I'm on Instagram. Facebook, you can find me. My name is Sam Wesley. Samuel Wesley, Samuel Wesley. I have also my law firm has a page, Sam Wesley and Associates, PLLC. On Instagram, it's at samwesley.esq. And if you go on any one of those pages, you can see my contact information. I have an office manager that schedules all my consultations and appointments. And our consultations are free, and my assistant knows the whole process, so a person can feel very comfortable talking to her, at least to know when it gets scheduled, and she can tell them the basic process of how we work.
Yes.
Yeah.
Man, that's it, man. Like I say, I appreciate that, man.
And our numbers. Let me give our numbers. So,
there we go.
all right, let me give good information. All right, so I gave social media, but our office number is 713-353-3960, 713-353-3960. My email address is sam, S-A-M, at wesleyanassociates.com. And my office manager, Tia Alexander, her email address is Tia, T-I-A-A, at wesleyanassociates.com. That is, the best way to get in touch with us.
Okay.
Yeah.
And to say, Sam, it's KT, episode 1, Raise the Bar. We gone.